we wiped the floor clean with the barrister for the council, and permission was granted on the day. Guess how much it cost for Cheltenham Borough Council to appeal that decision? It's disgraceful because they knew it was in an exclusion zone when we were in court. And what I really want people to understand about my case is that it's been hugely distorted by design by both the council's barristers and also the judge. And what the Labour government is planning to do now is to deregulate that, like what you're seeing in America. If we don't kind of stand up, you're going to see these masks popping up here, there and everywhere. I'm going to be doing private criminal prosecution, and if you want, I can provide you with the form, because the government don't want you to know about this.
Many moons ago, Carinna and I had the pleasure of interviewing Stephen Thomas and Karen Churchill, who were both battling in the High Court against 5G. You may remember that Stephen's case involved Cheltenham Council, where they had approved planning permission for a mast to go up near a residential area too close. It was in the exclusion zone, where absolutely nothing should be.
So, hello, Stephen. Welcome back to Council Watch. And we're here to find out on the updates on what's been going on with Cheltenham Council and all the 5G shenanigans you've been up to. So, let's talk about what happened in the High Court. So, away you go.
Hi, afternoon, Carinna. Good to see you again. Well, it's been a very long, drawn-out process. The High Court actually happened last year, back in April 2024.
Wow.
And prior to that, we had the permission hearing in November 2023. So before every hearing at any major court, be it the High Court, the Court of Appeal, the Supreme Court, there's always a decision on paper. And that, for me, is where the corruption is, because judges can do what they want on paper and there's absolutely no accountability. So the initial permission for judicial review got refused on papers, but then you're entitled to a permission hearing where you've got the chance for an oral hearing for half an hour to outline your case, why you think, it does stand a reasonable chance, etc. So that permissions hearing was in November 2023. And when we wiped the floor clean with the barrister for the council, and permission was granted on the day for judicial review. And
is there ever any explanation on why permission wasn't given? I mean, obviously, if you had a strong case, it should have been just passed through. Did it feel like just a strategy for delay?
What these judges do, they just tend to basically copy and paste what the council's barrister says, literally.
Right.
And I've had a previous judicial review when they've done exactly that, where a judge, who I won't name, but she had literally copied word for word what the council's barrister had said and used it in her judgment. So it kind of gives you an indication of what we're dealing with here.
Yeah.
But obviously, when you have a full hearing, it's a bit more balance of probability is more stacked, more favourable for you, at least anyway. But then, of course, they go away and they don't give a judgment on the day. They'll go to their chambers for a couple of weeks. They'll speak to their buddies down the lodge, and then they'll come up with some kind of a cop-out judgment, which lets
as plausible as they can make it in the decision they want.
Yeah, exactly. I mean, the High Court hearing back in 2024, April 2024, again, that was a full day, and there were 5 major points. So both sides had submitted their arguments, the full skeleton arguments, which the judge had read, and then it was a case of he would be asking questions and points which he wanted clarification on, and all the major points I won hands down, and the barrister representing the council was just didn't have an answer for some of these, and he was just left with his tail between his legs. So we all walked away really confident, thinking, what a great result. And then 3 weeks later, we get the judgment through. Well, I'd won the hearing, so my grounds had succeeded. But then he refused to grant me relief, so he refused to quash the planning decision. So I'd won, but I hadn't won.
Well, intuitively, that sounds wrong. Is it legal?
It's legal, but I wouldn't say it's particularly lawful. It's under what's called the Senior Courts Act, which the a previous government brought in, which basically gives the judge a discretion to say, in his opinion, the outcome wouldn't have been different if the unlawful behaviour hadn't have took place. So there was unlawful behaviour. The council was shown to be in error, but the judge decided that, in his opinion, it wouldn't have made any difference if that unlawful behaviour took place or hadn't have took place. And he did his own risk assessment. So there was objections from people in the retirement home 100 metres away, people with pacemakers and hearing aids. And he'd done his own risk assessment, which he's not qualified to do. That's what the council should do. And there was evidence before the judge to completely contradict what he had said.
Is it 500 metres?
Well, that's what Leonard Hardell recommends, the 500 metre setback.
So minimum.
This case, it was 100 metres away to the retirement home. And there was evidence before the judge that, people as far away as 110 metres without any medical devices can be affected. And what I really want people to understand about my case is that it's been hugely distorted by design by both the council's barristers and also the judge. So it became a singular issue about medical implants at the retirement home.
Right.
And that wasn't what the case was about. What the case was about was the fact that this telecoms mast was 17 metres away from people's bedroom windows, where literally they were eyesight with the top of the antenna.
So without that 4.5 metres vertical drop off that's supposed to be there?
Yeah, so there's what's called an exclusion zone. Around every mast there's an exclusion zone, where within that zone, even by ICNIRP standards, which is what the government uses, the International Commission for Non-Ionizing Radiation Protection, which is completely unprotective, even by their standards, there's an area inside there where it's unsafe for the public to enter. And that area is normally around 50 metres, and there's a 4.5 metre drop-off distance.
Right.
So that's why these ground-based masts, they're 20 metres or 15 metres to supposedly get around that, because people at street level aren't in that exclusion zone. So having that mast 17 metres away from a block of flats, literally at eyesight, it was definitively in an exclusion zone. We've got the compliance manual from the operator, which shows that exclusion zone ordinarily is 50 metres and 4.5 drop-off. And it can be dialed down. So they can do what's known as a fix-it solution, where they can dial it down, dial the output down incrementally. But there becomes a point, which is a stage 3 fix-it solution, where that power output cannot be reduced any further. And even in that situation, the exclusion zone is 28.5 metres.
Right.
And I think it's 4 metres drop-off.
So when they were doing the appeal, they were suggesting that 17 metres didn't matter. Or did they state it's in the exclusion zone or not? I mean, I know you tried to obtain the exclusion zones.
MBNL does the compliance calculations for free in EE, and I've got their compliance manual, and it clearly shows that these drop-off distances.
Well, I'm assuming the council have that manual too, or at least are aware that that's what the exclusion zones are.
Well, this is it. So but someone had actually requested these exclusion zones in an objection, and they were ignored. And the council don't bother to obtain them. And anyone with an ounce of common sense, with the diagrams there, which clearly shows, even in the diagram, shows the mast right next to a block of flats. Anyone with an ounce of common sense or integrity would question that, saying, "Well, hold up, that's a bit close, isn't it? 17 metres. It's firing straight into someone's bedroom window." I'm sure the case officer wouldn't have liked it if he woke up every morning and he pulled the curtains back and there was a 5G mast like staring at him in the face. They didn't obtain them. They didn't feel the need to check. In fact, health and safety played no part in their decision-making process, which they've admitted, because they think that once they get an ICNIRP certificate, that's all they have to do. They can wash their hands of it. we've got a safety certificate, which, by the way, only certifies that the equipment is in compliance with ICNIRP. It doesn't certify that the area around the mast is compliant.
Yeah.
So great, you've got
this is what the planning officers are meant to be checking.
I'm meant to be checking this, and it's disgraceful because they knew it was in an exclusion zone when we were in court. So on the day of the hearing, the barrister said to the judge that they've obtained the exclusion zones right at the very last minute, the day before the hearing. Hadn't shown them to me, but he'd sneaked them into the bundle without showing me. Luckily, the judge didn't want to see them, and because they hadn't been put in as evidence properly. But you can see the deceit of what they're trying to do to cover themselves.
Just underhanded.
Completely.
Left, under, right, under, left.
And they got destroyed about the exclusion zones, and the whole hearing was about exclusion zones. And then it got completely twisted to turn into about medical implants at the retirement home. So whenever
that's what's really interesting, having been there and watched it play out, and then look at what the written judgment is. If you weren't there witnessing, you would have had a whole different impression by what the judge had written in response, right?
Oh, completely. And it's so frustrating because people, to any person, be it a lay person, a legal professional, whoever, they read the judgment and all they think of is medical implants, and that's not what the case was about. It really isn't. And I really want to get this across to the viewers that it was all about the exclusion zones and how close is safe. And if you're at the High Court, I'm not sure if you're at the High Court last year, but
I was, yeah.
Oh, you were at the High Court. Well, that whole hearing was about exclusion zones. And then you get the barristers saying, well, there's no law or policy for us to check them. As if to say, well, we don't give a damn about, your health. There's no law or policy to say we've got to check them. Therefore, good riddance. And the judge had agreed with him, which was absolutely ridiculous, which is not the impression he gave on the day, as you remember. The judge was very kind of concerned and asking the questions, did you determine where the safe zone was, etc. But on the written judgment 3 weeks later, he just dismissed the argument and said, there's no law or policy. Now, of course, there is law and policy if you apply the EECC, because the EECC, which is meant to provide a whole list of conditions for general authorization systems, there's a whole list of conditions, and the EECC is being ignored by councils up and down the country and central government. They're trying to just bury it. Yeah. And the EECC did not get mentioned once in the judge's judgment, despite it being discussed extensively on the day. Didn't mention it once. So the judgment was completely distorted. It let the council off. And it's a disgrace, really. It really is. And it's left vulnerable residents living inside a radiation zone.
And of course, it would have been taxpayers funding their appeal against the judgment, wouldn't it?
Well, yeah, so this is it. So once that judgment came through, both sides appealed it. So it hadn't reversed the planning decision, and it hadn't, the judge hadn't properly applied the law. And Cheltenham Borough Council tried to appeal it because obviously that, it doesn't serve well for telecoms. It's shown that there is a risk when, of course, there is a risk. And the telecoms didn't like it one bit. So the telecoms and the council were acting together. I mean, even in the courtroom, you had the council's barrister with the telecoms company. They were just there next to each other talking and discussing. And so they appealed it on those grounds. And get a load of this, Carinna. Guess how much it cost for Cheltenham Borough Council to appeal that decision?
Oh, I imagine tens of thousands.
£60,000 of our money. Cost them £60,000 for that appeal, which we funded so they could try and overturn it. And they knew full well that there were residents living in that exclusion zone. It's just completely evil.
And let's not forget, the exclusion zone is only for humans without metal implants or, pacemakers or neurostims or hip replacements, etc. But it doesn't cover environment. It doesn't cover animals, because they know if they looked at animals, the studies are quite conclusive that it causes cancer. So we'll just be quiet about those ones.
Absolutely. Obviously, you've got the World Health Organization now in their study back in, I think it was March this year, even for a very compromised agency like the WHO to come out and say there's a link between cancer in animals and EMFs. That's quite big.
Yeah.
But obviously, there's hundreds, thousands of peer-reviewed studies, and the problem is ICNIRP only deals with biological heating effects, thermal effects. It doesn't deal with non-thermal effects, and of course, because we're energetical beings, we're run by electricity in our bodies.
Yeah.
And the damage that EMFs does to our electrical fields, this is what causes cancer and all kinds of problems and illnesses, because it destroys DNA.
And all of this is evidence-based, isn't it? So it's out there for anyone who's interested to look it up. The evidence is conclusive. So all we can draw is the conclusion that they know and they don't care. They want their progress and their 5G towers so much that it doesn't matter that it will compromise people's health or the environment, animals. It's unimportant, isn't it?
It's a disgrace. It just shows how captured both local government, national government, how utterly captured they are. And you remember from the court hearing that the barrister was there with the telecoms company. They were just there, just trying to wiggle out of everything.
But the judiciary too, by the written conclusion that the judge put out 3 weeks later, that didn't reflect what actually happened in the courtroom.
It's all captured. It's really demonstrated to me that no matter how strong your case is, like, you get thrown a few little, biscuits, if you like, but you're never going to win. And that case was so conclusive, open and shut. And Cheltenham Borough Council literally defended the undefendable.
Yeah.
I said it cost them 60 grand, but that's actually 100 grand, because the High Court cost them 40 grand just because they didn't want to back down. So all in all, it's cost the taxpayer over 100 grand, to try and keep the telecoms dream alive. It's insane. Then of course, like, you had the Court of Appeal hearing, which I think you were at the Court of Appeal as well, weren't you? Back in January this year. And Cheltenham Borough Council lost that appeal. So I then tried to take it to the Supreme Court, and we came up with a really great set of grounds, because the whole premise of the case about the prior approval, where they had said that prior approval wasn't required, it is required for a new ground-based mast. That in itself is such a strong argument. It's a strong issue of law, which is what the Supreme Court is concerned with. And the Supreme Court just washes their hands of it. They didn't even give any reasons. Just said it doesn't raise an arguable point of law, and that left it like that. So as I said earlier on in the discussion, they can do what they want on the paper. And whilst, you have Supreme Court hearings, which on the face of it seem like really balanced and fair hearings, 90% of cases don't actually get heard at the Supreme Court that get applied for. They don't want to take the controversial ones on.
And where do you go from there? Where's the social justice?
Well, there isn't any. And I know Karen and Neil are taking their cases to the European Court of Human Rights, but I'm feeling pretty worn out by it already. It's just,
That's how it works.
I put 100% in, and it's just there is no justice. There is no justice, and this case was an open and shut case, and they've failed. Both the council and the judiciary have failed in their duty of care to protect public health. It's as simple as that. You can't knowingly keep people inside a radiation zone. It's completely wrong.
It shut the door on a glimmer of hope that having all the evidence and getting in your day at court will provide justice. So more solutions needed to get remedy, isn't it?
Well, unfortunately so. As I said earlier to you, offline. I think we're going to have to come up with alternative ways to fight back. Maybe doing private criminal prosecutions against some of these council officers.
Yeah,
which is what I'm thinking of doing next.
Well, I think you're right. We're not getting through to them yet, because whatever mindset they have or the conditioning, it's just, full steam ahead. So we are going to have to think differently. The one positive I have is they've been collaborating for a long time and getting, everything in place. And we've been getting more organised, I'd say, in the last few years. Obviously, there's been individuals who've been doing what they need to do to challenge where they feel the fight should be. But I think the network is improving and awareness is raising. I mean, they can't throw the country to the dogs and expect even the slowest to not notice, right?
No, but I mean, the worrying thing now is you're seeing a lot of deregulation now of the telecoms industry. So whereas you had this prior approval system where it had to go through the planning system, the Labour government now is trying to put in steps or motions to deregulate this. To take it out of the planning system, to make it quick and easy for operators to put masts up anywhere. And there's proposed bill, I think, that's due to go in the next month or two, where they can make permitted development, really that simple for operators without the need for councils. So even though the councils haven't performed their jobs, it's at least slowed it down a bit. There has been some successes. And what the Labour government is planning to do now is to deregulate that, like what you're seeing in America. Because in America, they don't have any regulation. All operators can go and put their masts wherever they want.
Wow.
And that's what they're trying to get over here. And I think we've all got to be wise to that and put pressure on, MPs, councillors, national government, raise awareness. Because if we don't kind of stand up, you're going to see these masks popping up here, there, and everywhere, and you're going to have no way to object to them.
So I'm going to be looking at speaking to the local residents association and see whether there's action moving forward there, and see if we can marry up with Council Watch. I've got a few other things in the pipeline, which means I won't be focusing on any notices of liability, but I'll be looking at doing the head of planning, the planning officers that were on the documentation at the time, and also the auditors or the auditor partnership, because they should be flagging up when things are unlawful too, I think. So
absolutely. And what you've got to remember is all these people, planning officers, they hide behind their corporate indemnity. But as soon as you challenge them on a personal level, they get very frightened. And this is the way to do it. We had a lot of success in Gloucester a couple of years ago, where the head of development there, John Bishop, he had literally waved so many of these applications through without any consultations, and we'd put together a whole dossier, and we started really putting pressure on him, and then all of a sudden he was gone, resigned.
Because it's the gunning principles, isn't it, that's to do with consultation, and we haven't been adequately consulted. So that is another avenue that we can pursue to see if we can highlight where it's not going right.
Yes, and then obviously in Cheltenham's case with the mass that I've been fighting, the head of planning resigned literally a week after one of the residents in the exclusion zone had written in asking who was taking personal responsibility.
Yeah.
And once she'd done that, all of a sudden the head of planning resigned. And I can't say it was conclusively because of that, but
that's the kind of pressure we'll need. And if they manage to get replaced, then putting the pressure on the new person. So it's hard for them to get in post, hopefully.
Exactly. But I'm going to be doing private criminal prosecution, and if you want, I can provide you with the form. There's a form. Maybe you can put it as a link, because the government don't want you to know about this. But anyone can file a private criminal prosecution. They can put it into the magistrate's court. If you outline the grounds and the areas of criminal law which you believe to have been broken, then obviously the magistrates or the court will pick it up. And so it's not a guarantee for success, but if you could get, even if it gets these people into court for for a hearing or something, or they get a letter through, it rocks their mantra.
Yeah.
And when they knowing that there's potential criminal malfeasance for their actions, they're going to behave differently, you would have thought. So
well, we'll hope so. We have been trying to hold them to account for a little while now without much success, but we're all battling away. Now, we've got less than a minute left. So I'm going to say thank you very much, not only for talking with us today, but all the battling that you've been doing. Do keep me posted on any criminal prosecutions. And yes, send me the form. I'd love to have a look through, even if it's not happening immediately. We're going to be putting processes in place to make change, right?
Great. Yeah, that'd be brilliant. And yeah, wonderful speaking with you, Carinna. And
yeah, you too.
Well done for all the great work you've done in Colchester, because you've done some tremendous work. So.